Hey y'all, it's your girl Ariza, licensed clinical social worker, test prep guru, your personal hype squad, whatever you need me to be to help you level up and pass this exam. This is the channel that's going to give you the mindset, the content, the strategies, the knowledge, pretty much everything you need to level up and pass. So if you're ready to get those 4 letters behind your name, that LMSW or that LCSW, you're in the right space. So right now, I'm going to be talking about a topic that's it's come up quite a bit. I've put some things in my community about it, did some posts, did a little research on my own, and I'm like, maybe I should just do a video on it. I should just do a video on it and maybe kind of help the people and reel it in a little bit. We did have a nice discussion in the boot camp about it. So I'm sure those people have already leveled up and they already know the information. So if you have not done so yet, if you haven't joined the community, you haven't taken a boot camp, coaching class or something with your girl, I don't even know what to say. I just don't know what to say. I just know you're missing up on your level up game. That's all I'm gonna say. All right, so today I'm gonna go ahead and jump in really quickly. I'm feeling saucy. I love when I get a topic or have a topic that I'm going to discuss that I know you guys have been waiting for or wanting or needing more information or more elaboration, should I say, on it. It gets me excited. So I'm gonna go ahead and jump right in. And today I'm sharing my screen. Cheat sheet? No. So don't go in the comment section saying cheat sheet. Just go in the comment section and say you did that. Oh, wow, that is awesome. Whatever it is, go in there and level up and tell me how I did or what you think about the video. Before we even jump into it today, I'm going to tell you what we're going to talk about. We're talking about court orders and subpoenas. Yes, court orders and subpoenas. That's what we're talking about. Yes, I know that topic can be a little saucy and it can be a little confusing. When do you do this? When do you do that? But after this video, you're going to know it. You're not going to question it. You're not going to ask about it. You're going to see it on the test question. You're going to say, LCSWVIBES already told me that. I can hear her while I'm testing. I hear that all the time. I can hear you. I hear you in my voice. Somebody told me the other day they heard my voice taking about 150 or 160 questions of the exam. That's a lot of my voice in there. But guess what? My voice is telling you good things. It's telling you stuff to help you level up. It's telling you stuff to help you pass. And you know that person who heard my voice for all 150 of them questions, you know they pass. Yes, honey, they pass. That's what we do over there in the community. We pass. I got about 3-4 people I need to go ahead and give acknowledgments or shout outs to in the community, but we're about almost 1,000 people in that community. So it's huge. It's not like a Facebook community. It's a little bit more intimate, a lot more rigorous with some details and some content. It takes a little bit more to maneuver through it. So I hear you guys when you say it's so much. Oh my God, it's so much. I don't know where to go, where to start. I have a whole Loom video that tells you where to start and what to do. So that's just an excuse. And we don't do excuses over there. So go ahead and get in the community, move all around, figure it out. If you need some help, ask somebody. You post a question in the community, somebody right there ready to ask you. Well, not ask you, ready to answer for you. So keep that in mind. Let me go ahead and jump in. I'm going to share my screen. I love it. Subpoenas versus court orders. What every social worker needs to know. Yes, guys, this is something you need to know as a social worker. Trust me, I get calls about clients that I've serviced and worked with, and they're like, hey, we need you to do a letter, or we need you to do this, or it's a court order for this, or a subpoena for this. And it's like, it's so much. So you got to know this stuff. You're working for the agency, you're working in private practice. There's just some things that you got to know. So stay tight and with me as I go through this presentation and answer pretty much all your questions, everything you need to know to make sure you're good to go. So subpoena versus court orders on the ASWB exam. Don't guess, know the legal differences. All right, that's pretty much it. Don't guess, know the legal differences. And if you know the legal differences, it'll help you when it's time to actually answer a subpoena or answer to a court order. You'll know exactly what to do. All right, so again, that's why I'm doing this training, because I want to take the guessing game out and I don't want you thinking about what should I do. You'll know exactly what to do. All right, so why this trips people up? There's a lot of different reasons why subpoenas and court orders trip people up, because they are both legal documents and legal things that you have to address, but they're handled totally different. So the ASWB loves those legal ethical, I gotcha questions. So you got to know the legal terms. They sound similar, but have drastically different obligations and different meanings. So you'll see on a scenario that tests whether you understand when to protect confidentiality or when to comply. Yes, one, you can protect confidentiality. One, you can comply. So you got to understand when to do what and how to do a thing. So that is exactly why it's important to understand about these subpoenas and these court orders. All right. So a subpoena is a request for documents or an appearance in court. A subpoena is a request for documents or an appearance in court, usually issued by an attorney, not a judge. So let's recap, guys. Subpoena, documents, appearance in court, attorney. Those three things. Check, check, check. That's what you need to know. Now, this does not automatically override confidentiality. So when you get the subpoena in the mail, it doesn't mean, oh, I got to do this, and you go ahead and release all the client's records just because you received one. You cannot do that. You cannot just release all the client records because you got that. Now, the court order is a directive issued by a judge that requires you to comply. So subpoena is attorney, court order is a judge. So when you get a court order, it overrides confidentiality when it's valid. So you got to read that document, make sure it got everything in it, make sure it's signed by a judge, make sure it has all the legality to let you know, yes, this is a court order, because that lets you know automatically that you need to participate, or should I say you need to comply with whatever is being asked of you in that. It must be followed, but it doesn't mean you just go get the client file and just download all 1 million forms and documents of everything the client shared and just push it over. It must be followed, but only disclose the minimum necessary. See, sometimes as social workers and as individuals and as peoples, we like to do too much. I like to put us in the category of team too much. Team too much sees that and they send everything. Team, I want to make sure that I protect my client and I disclose the minimum necessary, is going to read it in its detail, in its entirety, and decide what they can get away with sending that's going to justify or provide what the court order says without providing absolute everything that the client has provided and shared. All right, now when you're responding to a subpoena, there's certain steps we got to do. And you'll see these in a lot of ASWB questions. It's like I put them in probably about 3 of my assessment tools or diagnostic tools to see where you are when you try to, when you do private tutor with me or joining the boot camp. We actually have an assessment tool to see where you are. And I'm looking at a certain score range that I expect you to be in order to say, okay, you're good, or hey, you better really pay attention while you're in this boot camp because you got some work to do. Kind of gauges where you are. So with that being said, I have a lot of questions that pertain to like subpoenas and court orders in there. So to make sure the people who I work with really know, they got to know a thing. All right, guys. So I had to come back through here and make a correction. Yes, I made a video earlier on court orders and subpoenas, what you must know for the ASWB exam. And I missed a step. I told you guys that when there is a subpoena that you contact the client, then you seek legal counsel, That is incorrect. You seek legal counsel or supervision always first, and then you notify the client. Simple mistake, but a huge, huge game changer when it comes to the exam, because that is something that can make all the difference. If the question says, what do you do first? What do you do next? And then it gives you those list of things, according to the video I did earlier, you're likely to contact the client first, and you don't do that. You want to make sure you contact the client when you actually have enough information, enough details, so they can understand what's being asked, what's being seen, what you can do legally, what you can't do legally. So that's why you want to notify or seek legal counsel or seek supervision. So those are the things you want to do first. And just because I made that error, and I know you guys are looking at this, I had to create a cheat sheet, something just to make it all easier for you, because I'm like, dang, that was a big issue. A lot of people were stressed out, messaging me in the comment sections, and I love that. So what I did is I made a social worker's guide to responding to a subpoena. Your girl got to go a little over and beyond when I make a mistake. I got to right my wrongs because I need you guys to pass. I don't need you messing up. And then it's something as simple as minute as that response. That can make all the difference. All right. So I'm going to roll through this really quickly for those of you that are part of the YouTube channel. Meaning you are a member, you subscribe, you pay that $9.99 a month. And I've been giving you the cheat sheets and the guides and stuff. This is one that I'm going to throw in there for you. It wasn't planned, but I am going to throw it in there because it's really important. I need you guys to really know. All right. So this chart outlines the correct 4-step process following when you receive a subpoena for client records. Super simple, very similar to what I shared in the last video, but we're going to cut that little part out or either add this part in. I'm not sure how my editor is going to do it. That's what they get paid the big bucks for. Well, kind of sort of. All right. So here we go here. Actions that we must do. Do not immediately release any records. First, your primary ethical obligation is to protect client confidentiality. That's according to the NASW Code of Ethics. Acting impulsively can lead to a breach of this duty. The correct first move is always to pause and begin the formal process. And of course, the formal process is to consult with legal counsel. Now, this is the most critical step for risk management. The lawyer will either let us know if the subpoena is legal, clear file the scope of request, advise if there's any legal obligations we have, all that kind of stuff stuff. That's what the lawyer's going to do. Then we notify the client. Now we can notify the client because at this point we have enough information from seeking legal counsel on how we should proceed. So after we get the legal counsel, you inform the client about the subpoena. They have the right to confidentiality, privilege, and all that kind of stuff. Now you can let them know the nature of the information is being requested. The client has the right to either consent to the release or assert privilege. That is when they assert privilege and say, hey, I object to this release. I don't want to provide it, This fulfills your duty to ensure that the client can make an informed decision. That is the 2 steps, guys, that was messed up in the last video. So I had to pull it and actually make this correction in there because I gotta get my people passing and not second guessing themselves. All right. Best most question. So if you get a best most question, this is kind of the final action. Based on the previous steps, if the client consents, you release only the specific information required, nothing more. And the client doesn't consent, your attorney will formally assert privilege on the client's behalf, typically like filing a motion to quash. And we talked about this in a previous video. So all that stuff still stands the same. It's just the order of things that I had to correct and fix. And I appreciate you guys in the comment section because that's why I read all the comments. Because sometimes your girl, I might make a little mistake. I ain't perfect, but I'm gonna go back and right my wrongs. That's what you got to know. You got to understand. I'm gonna right them wrongs and I'm gonna figure it out. I'm gonna do my research and make sure I get to the bottom line of it and do it. And for this one, it was honestly an easy mistake and error because it was just how it was worded on the presentation. I read it because I clearly knew the rules and how you actually do it. You guys in the boot camp or different parts of my course and stuff, that's kind of what you have to do. So that was actually a typo and I was just following along reading what I had in the presentation and didn't correct it. So for that, I do apologize. So remember, if the judge orders a court order, the video was provided, all of that stuff still stays the same. I just had to clarify that if a subpoena is issued, you will seek legal counsel, then you will contact the client. All right. So whenever there's seek legal counsel or seek supervision, you always do that first. That's pretty much like a gift. All right. So right down here, I got a little action. If a subpoena is given by an attorney, court order is given by a judge. We already talked about that. A subpoena, pause, do not release the records. You have the right and obligation to seek legal counsel, get the client consent, all that good stuff. If it's a court order and that's given by a judge, you got to comply. That still stands the same. I appreciate you guys rocking with your girl. Thank you so much for bringing that to my attention because that simple error can make all the difference. And I am not perfect. So I want to let you guys know that was an error on the last presentation. Hopefully this one will be edited. Maybe the other part will be completely removed, but if not, it'll be added in the beginning of the video so you guys can see this first and understand that it's correct order of things. Thank you for rocking out with LCSWVIBES. I see you guys later. Let's talk about responding to that court order. That's a little different. All right. So with a court order, you want to review the order to ensure it is valid and that it is signed by a judge. If it says Judge Judy or Judge Mathis or someone like that, then it's probably not valid. But no, seriously, on a serious note, you want to make sure it's signed by a judge and you want to make sure that it all aligns and it makes sense in what is being requested. And then you want to comply with the request, but you always want to follow the minimum necessary rule. So remember, we're not team too much here when it comes to court orders. We want to be team minimum necessary. All right. Not team too much, team minimum necessary. Just tell yourself team minimum necessary. That's who you need to be. You don't send your full file if only progress notes are requested. You know what I mean? Like you work with a client, you send the treatment plan, you send in all the assessment tools that you use to work with a client. You're sending like the release, like everything is in the chart. You just and sending it. No, chill out. It said progress notes. So that's what you sent. All right, guys, real quick. I'm always talking about the community, the LCSW vibes. We leveling up. And this is the sneak peek of the community. As you can see, it's on and popping. We got a lot happening. I got ethics over here, human development, or study guides that you guys asked me about on the YouTube channels. All right there. Test questions. You just want to level up and learn and see if you can answer those questions. I'm testing your knowledge. Let me go back to the home screen. If you want to learn more about what services I offer and what other things are there, that is where you go to the learning tabs. We leveling up. So why don't you join so you can level up too? The next thing is you want to inform the client unless the court order says do not notify the client. It just depends. Every state is different. So I have to include this because different states operate differently. So you always want to know what your state requires when it comes to these things. However, when you're taking, this is in real life, but when you're taking the exam, think in the context that it doesn't matter because all the social workers take it from all 53 states. Gotcha. From all 50 states. Everyone takes this exam. So with that being said, you want to think about it overall, the minimum necessary rule. You always want to inform the client. You always want to document all the steps in the legal guidance that you receive. These are the steps that you'll do because you don't really have an idea. If you're taking a test and you live in Kentucky or you're taking a test and you live in Maryland, Kentucky, the test ASWB doesn't care what state you live in. They just want to make sure you know how to handle a court order if it comes to that. So let's talk about subpoena versus court order. I want you to see this visual chart right here in front of you, like right there. And I want you to be able to see it so that way you understand it. We already talked about it. Who issues a subpoena? Attorney. Who issues a court order? A judge. Attorney. A judge. Judge. Attorney. So court order, judge, attorney, subpoena, subpoena, attorney. Like, you got to be able to know this stuff. Literally. Like, I'm playing around and I'm being lightful and, lighthearted and just kind of talking to you in a playful way. But I really need you guys to understand that. You need to know if someone walks up to you and says, who issues a court order? You should know automatically. Who issues a subpoena? You should know automatically. Which one requires release? Which one doesn't? A subpoena? No, it requires the client consent or legal review. A court order? Yes, you must comply. So these are the things that you have to understand. The actions: you want to notify the client, consult legal counsel or your supervisor. And then if it's a court order, you want to comply with the minimum necessary disclosure. Like, we're just not giving everything out, but we know we have to comply and give the information. All right, now what will happen if you ignore this? It could be possible contempt if you ignore a subpoena, and for ignoring a court order, it could be a legal penalty for non-compliance. So you really want to make sure that you're doing your due diligence and you're speaking to your supervisor, you're working with the legal team at your job or wherever you work, to make sure that you're complying and doing exactly what is asked and what is needed. All right, buzzwords. You guys love these buzzwords. So I figure in most of the videos, if I do the buzzwords, you guys are remembering them a lot easier. So that's why I've been including them, because it makes it easier to see and understand the thing. So let's talk about privilege. That is the legal right to withhold information. So a lot of times you hear the term, as a social worker, you can assert privilege. That is basically asserting your right, your legal right to withhold information, because you are a therapist and you're providing a service that is highly confidential, and you want your clients to feel comfortable when they're sharing their most innermost secrets and details with you. So you got to be mindful of it. You can assert privilege, you can do those things, but again, a subpoena is a subpoena and a court order is a court order. So just know how to handle each of those if it happens. All right, confidentiality. This is your ethical obligation to protect client information. That is in the code. It's in pretty much at least 100 million questions that you're going to see through your test prep journey. You got to understand confidentiality. Let's talk about compelled disclosure. This might be a new term that some of you ain't heard of before. So get your little sticky notes, your little tab. I'm not even going to show you note cards today. I'm going to show you a little tablet, and you can write down your terms. You should have a tablet right now, and it should say LCSWVIBES right across here, right there. And when you open it up, it should be the notes from all my videos. Yes, I'm almost hitting my 100th video. A lot of you guys are like, oh my God, I've watched all your videos. They helped me pass the test. I'm like, you watched almost 100 videos? And some people are like, no, but I watched 50 to 60 of them. That is awesome. 50 to 60 videos is awesome. Actually, I truly believe that if somebody goes to the beginning of my videos and watch it all the way to the end, I mean, all 90 of those videos plus, you got enough sauce and information in to pass the exam. You just got to take your notes. You just got to breathe. You just got to believe in yourself. You just got to meditate, all that good stuff. And if you feel like some concepts you need a little bit of one-on-one attention, check your girl out, because I do private tutoring, or you can join one of my other courses and help get the information to kind of sink in. At the bare minimum, join a community. That's where it's at. All right, jumping back in. So HIPAA versus ethics. Sometimes you can be HIPAA compliant, but still violate some ethics. So that's a word. That's a word. I want you to think about that for a minute. HIPAA versus ethics. So some of you guys, in another video I did, you put in the chat what the HIPAA stood for, and you guys was rocking out. I was like, dang, they know what HIPAA stands for. Because a lot of people don't. It's a long health information. I'm not going to go through it, but it's like portability and all this other stuff. It's a lot of terms and stuff in there to use. So some people know what it stands for, some people don't. But a lot of you went in that comment section and was writing. I said, they've been studying, doing their homework. So you got to understand what HIPAA is. HIPAA is basically like protecting, let's say, health information or health records. But let's talk about ethics. Sometimes you can be HIPAA compliant by not sharing or disclosing something that is a HIPAA document or a HIPAA, something that requires you to be HIPAA compliant. But in the process of doing that, you could be violating one of your ethics. That is a tough space to be in. And I want you guys to drop in the comment section if you can think of an example where you can be HIPAA compliant but still violate your ethics. So you got to think about that, because ethics first, baby, all day, every day. So tell me a situation where you might be complying with HIPAA, but you could also be violating your ethical duty as a social worker. All right, let's talk about the role of a client, privilege, and consent. Privilege belongs to the client, not the clinician. That means you can waive it. You can say, I'm waiving privilege, a certain privilege, all that kind of stuff. Because privilege belongs to the client, not the clinician. So you got to understand that. If a client wants you to release the records, they must sign a valid release of information, and you're going to release release them records. You know what I mean? So you got to think about that. You can assert it, waive it, and do all this kind of stuff, but the client has the privilege to say, no, you go ahead and do this, or no, you don't do that. So keep that in mind. Now, without consent, you must consult legal and determine if the subpoena is enforceable or if the court order overrides privilege. Let me run that back, because some of you went over your head and you're like, oh my God, this topic is so difficult, so hard. I just don't understand it. It's court orders, subpoenas, and oh God, if I get a question like this, if you get a question, it might be one or two. Calm down, guys. Take a deep breath. It's 170 questions, 20 are thrown out. It's 150 you're being tested on. Trust and believe. If you get one or two questions on privilege and subpoena and you don't remember it, you will be okay and you will still pass. But this is just going to help solidify and get those extra points in. So take a deep breath and just listen to your girl as I explain it to you again. Without consent, you must consult legal and determine if the subpoena is enforceable or if the court order overrides privilege. All right. So just go back to the earlier video, rewind this video. First watch it all the way, then go back and rewind it and kind of look at what I meant when I said subpoenas and then what I said about court orders and how this actual statement means that without a consent, you can consult with your legal and determine if the subpoena is enforceable, or if it's a court order, see if it overrides privilege. So you got to be able to understand those two and what they do, and that'll help you understand this. Social workers must also balance client rights, legal mandates, and ethical standards. So as a social worker, we have a lot that we have to do. We wear a lot of different hats and we do a whole lot. So that is important to take care of yourself and make sure that you stay on top of your game and you don't overdo it. Some of you guys are studying hours and hours and hours and hours that you're making yourself sick. You're tired, your immune system's low, you're not being able to do things in the best capacity or in your best way of doing it because you're drained and overwhelmed because you're so focused on passing the test when you already have everything you need. You just got to take a deep breath and trust in yourself. So these videos are going to help you do that, guys. I got to remind you pretty much every chance I get that you got to relax, take it all in, and believe in yourself. All right, NASW Code of Ethics. Safeguard client confidentiality to the extent permitted by law. Standard 1.07, I had somebody in my community last week. I'm giving you a shout out. You know who I'm talking about, Miss B, if you watch this video. And she was just throwing codes out. She was like, look, code 1.07 says that it encoded. I'm like, good God, I don't remember these codes. Whoa, this is next level studying. So yes, do you need to know the codes? Absolutely not. But if you do, it's great. It's kind of like I can tell you a verse or something that's in the Bible, but I can't quote the scripture verbatim, for those of you that know what the Bible is and have a little belief. That's the example. But another one would be like, I can tell you where to go at in the DSM for anxiety disorders, and I can tell you pretty much all of them and how they are, but I don't memorize what section, which one's first and which one's there, and exactly what the criteria is. I can tell you around about and give you a good summary of it, but I can't memorize each and every criteria in the way it goes. So that's kind of how this is. It's important to have an understanding of it versus understanding a specific detailed code or number. But standard 1.07 only discloses with valid consent or if legally required. That is what you must know. Only disclose with a valid consent or if legally required. So only disclose if you got a valid consent from the client to do so, or if it's required by law to do it or legally to do it. All right. Now keep in mind, state laws vary. So you got to know your state's guidance, but ASW questions use general principles. I told you guys that about 4 or 5 slides ago. The same test, I have a supervisee that's in Nebraska. I got one that's in Oklahoma. I got one that's in Mississippi, one that's in Virginia, one is in Maryland, one is in New York, one is in New Jersey. They all taking the same test. So it doesn't matter about what's happening in their state. You just need to know that in real life when you're working with the client. But for the exam, you just got to look at it as overall the general principles as it pertains to subpoenas and court orders. So that's why it's having general knowledge. Hey guys, let's stop by to tell you this. You do not have to win alone. Absolutely not. People in the community are winning each and every day. The proof is in the pudding. Go in the community. It's free. We're throwing down test questions, case studies, the FNBM method, all the details and everything you need so you can succeed. Click the link in the bio and join. You don't need to do this alone. See you soon. All right. Now, whenever you're in doubt, just consult with your supervisor or the legal department before releasing anything. So that's just key. If you're just stuck and you're like, I don't know what to do, how much I can release, whether I should release it, all that stuff, just consult with your supervisor. That's what they're there for. And if you have a legal department at your job or wherever you work, then check with them before you release anything, just to make sure you're doing what you're supposed to do. You know what the code says, but there's still certain protocol and certain things you want to do to make sure you're doing it right. All right, let me go ahead and ask you a question real quick. And this one right here. I try to fit everything on this slide so you can see A, B, and C are all like bunched together. But don't worry, because I'm gonna read it to you. A social worker receives a subpoena requesting the records of a former client in custody dispute. What is the best action? All right, I'm gonna read it back. A social worker receives a subpoena requesting the records of a former client in a custody dispute. What is the best action? A, comply and send the records to avoid legal trouble. B, contact the client and seek legal consultation. C, refuse to respond unless a judge is present. Now we know this is a subpoena, so automatically we know what we have to do when we get a subpoena. So tell me what your thoughts are. Put it in the comment section. Yes, the comment section. And while you going in the comment section typing up what your answer is and why, go ahead and like the video. It's all in the same thing. Like, and then automatically go in the comment section and write your answer. All right, thank you guys. I appreciate that. So the correct answer is B. Now, A, premature release is an ethics violation. So we don't want to do that. C is not realistic or professional. We wouldn't do that. C said you're going to refuse to respond unless a judge is present. A said you're going to comply and send the records to avoid legal troubles. Like you're just moving too quick, right? So the correct answer is B. You want to protect confidentiality, respect the client's privilege, and involve legal guidance. That's what you want to do. You want to get advice and guidance on how you need to move forward, and you want to protect their confidentiality and respect the client privilege. Absolutely. All right, so here's a practice tip that I want you guys to take away. What if the client is a minor? We didn't talk about that. We haven't addressed it, but this is important to know. If the client is a minor, what do we do? Minor consent varies by state, but again, by state. But then again, by state, it doesn't matter for the exam because the exam covers all states and it wants you to know things in a general context as it pertains to subpoenas and all that good stuff. So you want to still follow the same rules, but you do want to notify the guardian if appropriate. You want to honor confidentiality. We're protected by law, and you always want to consult legal before releasing information. So please keep that in mind. If you're getting a subpoena for a child or something, you likely would want to notify the parent and the guardian and all those kind of things and take those steps. So you definitely want to be mindful of it, honor confidentiality, and always consult the legal team or your lawyer or whoever you have at your agency or your clinical supervisor before you actually move forward to do anything. Are you studying for the LCSW or LMSW exam? Don't waste time on the wrong prep. Try my test prep program for free with a full module that gives you the real strategies, the real practice, and real results. Plus, you get access to my exclusive test prep community where you'll find support, study material, and accountability. No risk, no stress, just results. Click the link in the bio so you can get ready to win with the winning team. All right, so here goes some day tips, day one tips. These are tips the day of the test or of your whatever day it is. I just want you to understand that this is what you take in and you actually be mindful of and know. And this is especially, I like to say the day of the exam. So this is the day tips for the actual exam. If you see subpoena, default to client plus legal consultation. Subpoena, client, legal consultation. Subpoena, client, legal consultation. If you see court order, comply with minimum disclosure. If the question mentions like privilege, think, does the client give consent or does the client not give consent? That's what you got to think about. And then always remember ethics plus law, they both apply, but you must always protect the client unless a valid court order says otherwise. And what I mean by otherwise is the court order says you cannot notify the client or make them aware of it, blah, 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 blah. And it's signed by a judge and has all the details and logistics of it. Keep that in mind. That is when you do it. All right. So just remember when it comes time to take this exam, you are not expected to be a lawyer. You are expected to protect your clients. So slow down, read carefully, and when in doubt, always consult before you disclose. Always consult before you disclose. So I know this video had a lot of information, even though we only talked about subpoenas and court orders, but I hope you have a very good understanding of this topic and you're not questioning it or second guessing yourself or not sure of how to handle a thing when it comes there. I try to make it as simple as possible. Make sure you can always go back and look at the video. So make sure you do that. You could always go back. If I was you, I'm not giving a cheat sheet. So you might just want to take a picture of this visual chart just to see it and just to understand it and use it as like a memory aid to just make sure it guides you through this actual presentation so you know how to use it and how to go from there. Again, I want to just give a shout out and thank each and every one of you who've joined this channel, who joined my community, who's also joined my YouTube channel. It is such a blessing and it is such an honor to serve you guys and to be a part of your test prep journey. I live for the comments about how you aced the test, how you passed the test, how you walked in hella confident, and how you just made all the difference in your test prep journey, or how I've helped you and how was an instrumental part in that process. You have no idea what that does and how that makes me feel. So I appreciate you guys keeping these comments coming. I appreciate appreciate you guys leveling up and letting me know where you are and how you are doing. I appreciate you. My dogs, see my little fur babies over there, they looking like, oh my God. Yes, they both appreciate you as one behind the other. But I just want to let you know that I appreciate you leveling up. And most importantly, I appreciate you starting to believe in yourself. So many of you are telling me, I second guess myself. I second guess myself. I second guess myself. And you realize second guessing yourself is stopping you and preventing you from elevating and moving on to the next level. And that means getting that license. So you just got to tell yourself, stop. When you start guessing against yourself or thinking that what you're saying is wrong, if you don't have proof to show that what you're thinking is can contradict what you're thinking, stick with your gut. 90% of the time, you guys are right. So if you're right 90% of the test by trusting your gut, and it's only a 10% chance that maybe the other answer is right, I'm gonna go on that larger side of 90%. Because I'm telling you, I had so many people that told me that, but they decided to level up and listen. And they went in that exam and they kept hearing that little voice tell them, change it, do this, do this. And they were like, no, I hear Riza in my ear saying, don't change the answer, don't change the answer. So I'm glad my voice is loud, but I want my voice to be loud, telling you the right things and the things that's going to help you get to where you need to be. We all have those voices inside our head, and we have to ask, is this a good voice or is this a voice that I need to disregard? Hopefully my voice is that good voice, and it's helping you understand and be able to utilize this information in a way that's easier to digest and to maneuver and move through with it. So at the very least, make sure you join the community, guys. I got the boot camp coming up. I got the dates for the boot camp, arizahillman.com/boot camp. The dates for the next ones are up there. The early bird special probably has ended, but check it out. Maybe it's still there. If not, invest in yourself. It's going to definitely help you level up. I got tons of reviews for people who have taken the boot camp. And I would tell you, those who have taken the boot camp, the success rate is probably about 80-85% right now for individuals that's taken the boot camp and tested already that have passed. There are a few people that have not passed, but again, it's from the second guessing, not being truly ready, and just being forced to do something with the date. So a lot of you are reaching out to me like, should I test? I have a few things that I measure and a few things that I look at to determine if you're ready to test or not. So if you're in my community and you're like a paid member of the coaching community, or you're in the course, or you're in the boot camp, or you do private tutoring with me, trust and believe I'm not going to let you take that next step or that next level without making sure you're right. Without making sure you're right. I'm going to look at you, you're going to look at me, and we're going to do this little assessment to see if you're ready to actually go and spend it. Because I don't want you just going out there throwing this 250, 260, whatever it is, out the drain, just throwing stuff up against the wall and hoping you pass. We're going to make sure that you're ready to pass. So those of you that elevated and invested in yourself, your girl got you. I'm going to rock out with you until you pass. That is guaranteed. And I know you're going to pass and rock out. So be blessed. Until the next one, you have an amazing, amazing, amazing day. Make sure you do so on purpose. And most importantly, believe in yourself. Tell yourself how amazing you are, how you were meant for this, how you're an amazing social worker, how you're going to be licensed within the next whatever days or time you're taking the test, and just speak it into existence, guys. I need you to visualize that you got this. All right. You have an amazing day. Make sure you like, subscribe, tell a friend, share with another social worker. And remember, this channel is all about winning.